Members of the Medical Board, good morning. Good morning. It's good to see everyone again. I'd like to again ask all of us to please turn off your cell phones to silent and make sure they're off the table so we can avoid unnecessary feedback. I'll do that myself. This is an official business meeting of the Medical Board of California. As such, disruptions of the board's business will not be tolerated. We have designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask that person to conduct himself or herself in such a manner that permits the board to transact its affairs. This meeting is available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press 1. You will hear a tone indicating you are in the queue for comment. If you change your mind and do not want to make a comment, press pound. Assistance is available throughout the teleconference meeting. To request a specialist, press 0. Each person will be limited to 3 minutes per agenda item. However, during agenda item 13, public comments on items not on the agenda, the board has limited public comment period for individuals on the teleconference to 20 minutes. In addition, public comment for individuals here at the meeting will also be limited to 20 minutes. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Mr. Vang will be assisting, to my right, assisting me with receiving public comments via teleconference during the meeting. And let me just say that we set out these minutes as a goal and as time frames. Of course, if members of the public wish to speak within the allotted 3 minutes, we will, as is the board's practice, we will allow that. But we want to ensure that we get to all of our agenda items. The board welcomes public comment on any agenda item, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand and you will be recognized. I would like to remind all speakers to complete a presenter slip so I can call you by name at the appropriate time and that the record of this meeting can be full and complete. Please give the speaker's slips to Ms. Lisa Toof. Ms. Toof, can you identify? Hello. Good morning. She has the speaker's slips. I will do my best to call upon everyone who has supplied a slip for an agenda item and will recognize those who wish to make a last-minute comment. But we ask that you fill out a speaker slip after your comments so we have a complete record. I want to remind all speakers to please stay on topic and keep your comments within 3 minutes or less. We will try to end this meeting by 2 p.m. We may take some items out of order to accommodate that schedule. Before I call the meeting to order, I want to introduce staff members that have joined us here at the front. To my left, our Executive Director, Kimberly Kirkmeyer. To my left, our General Counsel, Ms. Webb, and Ms. Dobbs. Thank you. I would like to call the meeting to order and ask Ms. Toof to please call the roll.
Dr. Bishop?
Here.
Dr. Diego? Here. Dr. Gonadev?
Here.
Dr. Kraus?
Here.
Ms. Pines?
Here.
Dr. Lewis?
Present.
Mr. Louie?
Here.
Ms. Shipsky? Mr. Serrano-Sewell?
Present.
Ms. Wright?
Here.
Ms. Yaroslavsky?
Present.
Dr. Yip?
Present.
Dr. Levine? We have a quorum.
Thank you. We'll go on to our first agenda item for today. Item 13, is that right? Yes, 13, thank you. Public comments on items not on the agenda. I have no speaker slips. Oh, yes, ma'am. Please approach and state your name. Oh, thank you.
My name is Tara Kittle. I just wanted to make a brief comment regarding something that happened yesterday, and this is the first time I've spoken. I'm not really sure now is the right time to say this, but there was a point made on items on the non-agenda yesterday regarding physicians being required to notify patients when they come in if they've had disciplinary actions against them. I have a really big problem with that. I feel like if the physician has been deemed to be safe to treat the people of California, then that disciplinary action has happened in the past. It should be in their record. It's there if you want to investigate. But for the physician to actually notify that, they're basically saying to a generally uneducated public who doesn't quite understand how the process works, I did something bad. Well, if the implication is they might do something bad again, then they shouldn't have a license and they shouldn't be practicing at all. But if the issue's been considered, dealt with, and resolved, then it should be in the past of the physician. So thank you very much.
Thank you for your comments. I have another speaker card. Dr. Anthony Jackson.
Dr. Jackson, I need to remind you that you cannot speak on a case that may come before the board. You can speak in generalities.
Yes, I'm perfectly aware of that. Thank you. Good morning, members of the board. I am appearing this morning on behalf of the First AME Churches, the NAACP of California, and BAPAC, which are two of California's largest civil rights organizations. And I'm going to read a brief statement, and then basically what we're looking for is to see if this matter can be placed on the agenda for the next quarterly meeting. But anyway, the American Medical Association, AMA, has remained our nation's bastion of healthcare since it was founded in 1847. Cotton was king and slavery was the law of the land. An epiphany occurred on July 10, 2008, when the AMA issued its global letter of apology to all black physicians for more than 150 years of racial discrimination. This apology further acknowledged other dishonorable acts of omission and commission practiced by the national office and some affiliates. This long overdue apology was welcome as a giant step towards the healing process, and it helped explain the racial disparities in health and healthcare which still exist in America today. On October 25, 2009, BAPAC and the California NAACP jointly adopted Health Resolution Number 4 to address these disparities, and an attachment is here in this communique. These are California's two largest civil rights organizations, and it begs the question, why are mortality, morbidity rates for blacks still disproportionately high, even when socioeconomic status and comorbidities such as smoking, diet, drugs are statistically accounted for? This disparity in particular is apparent in California. What X factor might explain this? Could the self-acknowledged institutional racism of the AMA have trickled down to its affiliate state medical boards? That's the rhetorical question. And psychiatrist Dr. N.O. Prim observed that the professional well-being of black physicians has a direct impact on the health and welfare of their patients. And that was published in the September 5th, 2008 Psychiatric News Journal. As we all know, another seminal event and epiphany occurred just days ago regarding the Donald Sterling matter, when this brave new world showed its intolerance for racism.
Dr. Jackson, you must conclude your comment. Your 3 minutes are up.
Okay. Anyway, I have some handouts with the rest of it, comments. Thank you very much.
Thank you. Are there any other comments on agenda items, on items not on the agenda? Are there any comments via teleconference?
Yes, we have a question or a comment from Ray. Please state your full name and your affiliation. Your line's open.
I'm Ray Groylick. I'm a California healthcare consumer and a member of the Hospital-Acquired Infection Advisory Committee for CDPH. As more and more California healthcare consumers are turning to outpatient settings for more invasive procedures, these outpatient clinics should be required to report their infections to the state, just like California hospitals are. There are other states doing this: Colorado, Texas, I believe Illinois, Pennsylvania. These states currently require their outpatient clinics to report, and I would like to see the board sponsor legislation to this end so that California healthcare consumers are afforded this protection as well.
Thank you for that comment. Are there any other comments on the teleconference?
If you have a comment, press *1 at this time. And there are no more comments. You may continue.
Thank you. Seeing no further comments, we'll move on to item 14, update on the Enforcement Committee.
Thank you, Mr. President. The Enforcement Committee met yesterday. The committee received the presentation by Ms. Kirschmeyer on the MOU between Medical Board and the Department of Consumer Affairs related to the transition. The presentation on the MOU, which documents the agreement between the board and the DCA and defines the relationship between those parties, included information regarding the responsibilities of the DCA and the board and specific roles for each party during the transition. The committee also received an update on the progress of the transition staff pursuant to SB 304 from Mr. Gomez from DCA Division of Investigation. Mr. Gomez reported that town hall meetings are scheduled for next week and will include participation from all impacted employees, including the board and DOI. Mr. Gomez also reported that meet and confer sessions had occurred between DCA and the impacted bargaining units. Mr. Gomez has completed his meet and greet visits with all the board investigative staff. He reported that he has formed a team which includes representatives from the board and DCA to work on a rewrite of the VE manual. This rewrite will be completed prior to the transition on July 1st. He notified the committee of the 2 swearing-in ceremonies for sworn staff, one in Riverside on June 30th. Actually, yours truly will be attending that one, which is close to home, and one in Sacramento on July 1st. Board members are welcome to attend either ceremony. Ms. Kirschmeyer and Ms. Cady provided a presentation and statistical report. The presentation included data currently received by the board and a recommendation to simplify the data received by the board after July 1st. The committee requested to receive the data on the investigation timelines and complaints opened on cases in a closed bar graph format. It was somewhat confusing report, but I think we want to make it simple. The committee also received a report that included data on interim suspension orders, that's ISOs. The data included the number of ISOs of requested and granted. The committee requested additional information regarding how long it takes to request an ISO after a complaint is received. And lastly, the committee received information that clarified the role of the medical consultants, who are the board employees, versus role of expert reviewers, which are independent, unbiased reviewers of the board. And this ends my report.
Thank you, Ganadev, and the committee for its hard work. Are there any questions or comments from the board regarding the Enforcement Committee report? Seeing none from the board, are there any comments from the public present? Seeing none, are there comments on the teleconference? Oh, I'm getting some speaker slips. I'll start with the teleconference.
Once again, if you have a comment, press *1. And no comments on the phone. You may continue.
do have public comment. The first one will be, oh, these are both on 17. Disregard that. Thank you for the report. Moving on to our next agenda item, item 15, Vertical Enforcement Program Report. Ms. Castro.
Good morning. I'm Senior Assistant Attorney General Gloria Castro of the Health Quality Enforcement Section in the California Department of Justice, serving Attorney General Kamala Harris. It's always an honor and a privilege to appear in front of you. And I wanted to start off by advising the board on an update on the case of Carotino versus Linda Whitney. That particular case involved Dr. Carotino, who came to the board's attention in 2011. By February of 2012, an investigator along with one of our DAGs had identified 5 patients from a cures report for possible procurement of medical records. And since then, we've been requesting these records. And most recently, the Court of Appeal agreed that the medical board has the ability, along with other law enforcement agencies, such as the Board of Pharmacy, to mine cures in the way it was intended, which was to prevent patient deaths. And the long and the short of it is that Dr. Carotino, as is his right, appealed a trial court order granting the medical board's petition to compel compliance with investigative subpoenas. And subsequent to that, there was an argument submitted by Dr. Carotino, supported by the California Medical Association, that argued that the board's access of cures, absent of showing of good cause, violated the patient's right to privacy under the California Constitution. In a published decision, the Court of Appeal resoundingly upheld the board's use of cures, and it found that the board was authorized to review cures data under Health and Safety Code Section 11165, and that the board's, quote, limited incremental intrusion upon a patient's privacy is justified by the state's countervailing interest in preventing the abuse of controlled substances. So this was a victory for not only the boards involved in preventing patient deaths, but also my boss, the Attorney General, who manages the cures program. And as has been noted during this board meeting, it's currently being revamped to make sure that access is assured to everyone that needs access to it, stakeholders, including pharmacists, doctors, and such. I'd like to announce some of the staffing changes in health quality enforcement. DAGs Carrie Weissel from our San Francisco office and Robert C. Miller from Sacramento will be retiring after long and illustrious careers with the state of California, serving patients of the state of California in the health quality enforcement section. I'm happy to announce 2 new people will be joining our staff. Carolyn Westfall, San Diego City attorney formerly, and Christina Sen, who comes from a big law firm, will be joining our San Diego and LA offices respectively, both on June 2nd, 2014. I'd like to move on and address a couple of points. With respect to pro law, I know it was mentioned yesterday, Board Member Yaroslavsky has always been the one that really brings up these questions, and I wanted to just make sure that I wanted to inform the board that the Attorney General is looking for a way to provide a portal so that relevant information needed for the board can be accessible. However, I will tell you that it's a wider policy issue than the health quality enforcement section, and we're a law firm. And I'm looking at Mr. Serrano-Sewell. Law firms traditionally do not allow their clients free access to their attorney-client privilege work product files. However, I think it's important enough to provide markers that the board needs in the way that they can manage that information. So can it marry with Breeze? No, not now, maybe not ever. However, we're finding a workaround. It's important enough to everyone that we get you the information you need, other than bills, other than the various reports that I provide Ms. Kirchmeier. I continue to meet with Kimberly Kirchmeier. I have become more involved in the process over the past year of making sure that every single staff member in HQE manages this program in a similar way. At the same time, I'm very, very confident that as we move on to our DCA partnership, that the work will continue. I must say that I have never seen this program work more efficiently than in the last 6 months, and I hope that that tempo continues after July the 1st. We're managing cases very quickly, we're being responsive, and it works. So with that being said, the Enforcement Committee should probably consider meeting with DOJ, the Medical Board, and DCA staff prior to July 1st. My recommendation would be just to get on the same page and once again memorialize the agreements that we already have with Ms. Kirchmeier and Ms. Threadgill as to what means what. And for instance, you have stats in front of you that you received yesterday. There's a particular marker called case referred for action. That means that either the date that the Attorney General signs the report of investigation in VE cases, or in non-vertical enforcement cases, it means the date that the Medical Board sent a case over for our consideration for filing. So I would strongly urge that a meeting happen where we can discuss what milestones mean and don't mean, or just to refresh everybody. And it's more for the benefit of DCA possibly, because I think the Medical Board and DOJ are on the same page. I keep hearing about measurements of efficacy post July 1st, 2014. The Attorney General will be tracking brand new cases that get referred to the district offices, and that means brand new cases, not cases that were halfway working. And hopefully we'll be able to identify whether anything's getting slowed down, and I can bring those to the attention of Ms. Kirchmeier and Ms. Threadgill and Mr. Gomez. As we move forward. I think that there will be a lot of cases that are going to be hybrids, worked under the Medical Board, and then transferred over to DCA and then finished with DCA. But the true measure of whether things are going differently or going just the same or better would be to see brand new cases and see how those work through the system. Our investigators that we work with and the Deputy Attorney Generals work very, very hard on this program and individually on the cases. And it's a good partnership. So we're really hoping that that continues. As with respect to the vertical enforcement manual, I sent the version that was approved by my chief and the executive staff at the Attorney General's office. I sent that version over on February 14th, 2014. On March 4th, 2014, I was informed that DCA is looking at the VE manual and restructuring it. I have to say that the VE manual that we have right now is very detailed, and that is a reflection of a continuing partnership where we don't want to waste time talking about how to do things. We want to talk about how to get the doctor, get the records, talk to the patients, close the case, or transmit it. So for myself, I think I speak as an attorney and also as someone that's very, very meticulous and very involved in the details. The more detailed something is, the less questions there will be. And I think patients are owed that there will not be any discussion that slows down cases because we don't know how to do it or how to manage a case. It's just all there. So I'm looking forward to seeing the version of the vertical enforcement manual that DCA drafts. However, what I would like to avoid, and I've told Mr. Gomez this, is that the Attorney General not have her own version of a manual on July the 1st. I think it would be better to have a joint manual. However, from a management perspective, HQE needs to make sure that our staff continues on the line that they were on, and very likely it would be exactly the same manual with the names changed and maybe management structure in there. I just need continuity, that is all. And we can continue to work on a joint manual, but as we are already, like in May 1st, 2014, the likelihood of having a joint manual by July 1st is, if we work really hard, I'm there wherever they want me to be, and maybe we can do it. But hopefully we'll be reporting at the next board meeting that we have a joint manual. And that is all I have. So thank you so much.
Well, Ms. Castro, thank you for the report and the hard work of your office and the Attorney General. Please extend our deepest gratitude and appreciation to your retiring staff.
Thank you. We will.
Members, do you have any comments or questions? Ms. Yaroslavsky?
I want to thank you for the report and I want to thank you for your efforts and engagement in making sure that as we go forward, after all these years of trying to make it work, that things might work. I am very distressed to understand that there is no joint manual to date, and I'm very appreciative of the fact that you realize that we need to go forward on a continuing basis as we have been. But I don't know how to push this point better than to say that it's very nice to work in a vacuum, and it's very nice to rearrange deck chairs on the Titanic. But in the end, the ship has got to sail. And I understand that, and I appreciate you understanding it, and I know our staff does. But I don't know what you can do to push this further, but I would urge you to, it's not fair to your staff, it's not fair to our staff, to not know for sure what's going to happen in the future. And no knowledge and lack of knowledge is not a good work ethic. So I appreciate your comments, and I appreciate your support. And it seems like we have a very new face almost going forward of collaboration and cooperation, and I appreciate that. And please extend that, my remarks to your boss as well.
Thank you, Board Member Yaroslavsky. It's important that we not set a reset button, but a pause and continue.
Perfect.
From June 30th, from when your investigators get sworn into DCA. And we will work hard on that. But we do need some direction for our staff. And
I'm happy to give you direction.
Right. But the VE manual, as it stands now, the current version will be what we will be executing as part of our business process.
Dr. Ganadev?
Mr. Castro, it's always a pleasure. I know it might not be under your purview, but I wonder if you have, if you're aware of when can we have cure system robust, user-friendly, and usable, just usable, period. It's that bad right now, so I'm just curious if you have any thoughts on that.
I have insights on that, as you've pointed out aptly. The Attorney General is where the cures system is currently housed. We have one Deputy Attorney General assigned to that work group, Deputy Attorney General Edward Kim, whose area of expertise is pain management. We also have an Office of Patient Privacy that the Attorney General has in her office. It's been around for about 2 years, so they're very involved in cures. And believe you me, nobody wants to be left holding the bag where somebody didn't have access to it and one of their patients suffered as a consequence, or a doctor ended up before you without needing to be. I don't have a timeline, but I can tell you they meet very regularly, every 2 weeks, and it's very robust. And so my hope is that the rollout can occur as quickly as possible. And remember, there's a whole new emphasis on new users. So whereas the cure system has always been there for the pharmacists to put in the data, and for doctors that are practicing under the standard of care to pull data from, we're adding 40,000 new users just from one of the boards. And so this is a multi-user platform, and DOJ, I think, is the proper place to have the Cures program, because we do manage CLETs, we manage fingerprints, we manage the Megan's Law. So they're working hard on it, I assure you. And I can probably come back with a better update, or get the proper person to Kim so that they can present at your next board meeting.
Thank you.
Thank you.
Any additional comments to my left from the members? Seeing none, Ms. Kirkmeyer?
I'd just like to publicly thank Deputy Attorney General Esther Law and the AG's office for their support in that Caratino case. It was a huge case for us. It was a big win, and we just really appreciate the hard work that went into that.
And I want to thank the investigators and supervising investigators involved. It was a true team effort and a big victory, like I said. Any time that we can have a team effort result in something that betters the future cases for investigators and DAGs, it's just a victory for everyone. So your investigators are fabulous. I don't know if Ms. Threadgill is here, but thank you to her as well.
Thank you. Thank you.
Thank you.
Any additional comment any public comment from members present? Seeing none, on the teleconference line?
No comments at this time. You may continue.
Thank you, Ms. Castro.
Thank you, sir.
On to the next agenda item, 16, update on the prescribing task force. Ms. Yaroslavsky and Dr. Bishop. Dr. Bishop.
Thank you very much. On February 19, 2014, the Prescribing Task Force held its second meeting. This meeting focused on potential revisions to the Medical Board's pain management guidelines. The Board's pain management guidelines were developed in 1994, but were most recently revised in 2007. Invitations were sent to representatives from prescribing and dispensing communities, law enforcement, consumer groups, other regulatory boards, associations, other state agencies, pharmacies, pharmaceutical companies, and legislative staff. The meeting began with a brief overview of the Medical Board's current pain management guidelines presented by Ms. Threadgill. Dr. Scott Fishman, representing the Federation of State Medical Boards, provided a presentation on the Federation's recently issued model policy on the use of opioid analgesics in the treatment of chronic pain. Dr. Richard Reamer followed with a presentation on the Canadian guideline for safe and effective use of opioids for chronic non-cancer pain. After the presentations, the task force went through the Federation's policy to see what items should be considered for inclusion in the Board's revised guidelines. Members were able to receive electronic feedback from the audience. Those items where majority consensus was not obtained were discussed with the group. The task force was able to review approximately half of the Federation's policy at the meeting. The next meeting will be held in June, where the Board staff plans to provide draft revised guidelines for the task force and interested parties to review. Additionally, the Board recently received a document on prescribing opioids from the California Medical Association that provides some valuable information that will also be reviewed. The Board hopes to bring the revised guidelines to the Board for review at the October Board meeting. As stated during the last Board meeting, after the task force revises the pain management guidelines, it will look at best practices for prescribing opioid medication. We want to gather as much information as possible from all interested parties and subject matter experts. We want to use this information on best practices to establish newsletter articles, a website specific to the best practices, outreach presentations, and other educational tools for the physicians and the public. Are there any questions?
Questions, members? Thank you for that. Ms. Yaroslawski, anything to add?
No, I echo his remarks.
Thank you, thank you.
Oh, Mr. Toronto-Sewell, on a personal note, aside from the written stuff, it was a very robust meeting. I think everyone felt very involved, the participants in the audience, other people were very involved in this process, very passionate, and I thought it was a very good outcome from that meeting. And I hope to continue that with the next meeting.
Thank you for your continued hard work on this important topic, and once again, that video is fantastic. And thank you for doing that. Appreciate it. Are there any comments on the report from the public present? I do have one speaker card. Ms. Yvonne Chung.
Good morning. My name is Yvonne Chung with the California Medical Association. I just wanted to reiterate Dr. Bishop's comments regarding the report that CMA has put out regarding clinical guidelines. This report was developed by our internal council on scientific affairs, which is a multi-specialty group of physicians. The intended audience was really to provide clinical guidelines for not necessarily for physicians who are experts in pain management, although the guidelines were developed by experts, but for your I don't want to call anybody an average physician, but someone for whom this is not their specialty, so that they would have very robust guidelines to work from, and we look forward to working with the board, and we appreciate being included in the process. Thank you.
Thank you. Are there other comments from the members public? No. Oh, yes. Yes, Doctor.
I think on that point, it is important that on the enforcement side, what we see is it is the primary care physicians who get into trouble with the prescription drug issue, not the pain management doctors. So our goal is to educate the people who are not experts at pain management really to follow the guidelines.
Mm-hmm. Thank you. Are there any comments from the teleconference? Oh, was there?
If I could just answer Dr. Nanadev. One of the things that I like to focus on is that whatever guidelines we come up with, these have to be easily followed by, as you say, the non-pain specialist. Because if they're not easy to follow, many physicians may just stop practicing in that area, leaving our patients at a loss for where to get pain medication when it is indeed indicated and needed. So we're working with that in mind, that we need to have guidelines that are applicable both to the specialist and to the non-specialist to provide the best care and safety for our patients.
I would like to just remind the board that our main focus here is to protect the consumer. It's very nice that we're going to try and come up with guidelines that are going to be followed by the majority of the medical practitioners. And the CMA report was more than helpful and of value, and I want to thank them as well. But I think that the sooner we can get this moving, and the sooner we can come up with appropriate methodology to ensure safe practices for not only the physician, but for the consumer to know better and to be smarter about what they're doing, the better off we're all going to be.
Is there any additional board comment? Great, we've heard public comment. Is there any comment on the phone line?
We have a question from Dr. Lang. Please state your full name and affiliation. Your line is open.
Thank you very much. Good morning, and thank you for this opportunity to address the Medical Board of California. My name is Dr. Khadijah Lang, and I am the Vice Chair for Region 6 of the National Medical Association, an organization of physicians that has represented and defended the concerns of physicians of African descent since its founding in 1895. Currently, it's serving, among its other duties, as the voice of advocacy for over 50,000 African American doctors and the patients they provide health care to. Region 6 includes the 14 westernmost states of the country, bounded by Alaska on the north, Hawaii on the west, California on the south, Colorado and the Dakotas on the east, and many of our members reside in one of these states other than California, but are dual licensed, practicing in California as well. Thus, they also come under the regulatory purview of this board. The National Medical Association has historically focused on health issues related to African American physicians, minorities, and the medically underserved, and is committed to the elimination of health disparities and the promotion of healthy lifestyles. To that end, we believe that achieving this goal requires qualified and competent physicians who are committed to and capable of providing high-quality care to these patients in a culturally sensitive manner. In my position as Vice Chair, in addition to California doctors, I've now received complaints from members of several other states about the seemingly unbalanced and disparate treatment they've experienced when they've had encounters with the board here in California. Our members are comparing the stipulated settlements of their cases with those they see in the medical board newsletter and finding significant differences in the severity of the terms and conditions given to them versus that seen in the newsletter for the same or similar accusations and decisions made against majority doctors. Additionally, they're concerned about the manner of distribution of investigators, in which there appear to be more investigators per physicians in minority neighborhoods than majority neighborhoods, even though there are fewer physicians in these minority neighborhoods.
Ma'am, Dr. Lang?
To give the appearance of minority of, yes?
Oh, yes, Dr. Lang. If you could please wrap up your comments. They're not directly on point with this agenda item. So if
Yes,
you can
I will wrap them up.
Thank you.
You're welcome. Our concern is that this makes it appear that there is more fraud going on in certain neighborhoods, when in actuality the dollar amount is much higher. And this type of behavior is of even greater concern in 2014 as the Affordable Care Act rolls out in California, with more patients being brought in to our healthcare system at a time when we're already facing physician shortages that are greatest in the minority and underserved areas of our state. When a practicing African American physician is taken out of the already shrinking pool of doctors to these areas for non-patient safety issues, it has a greater impact on the resultant doctor-patient, and as such is much more detrimental to these communities' health than when a doctor is removed from a majority area. We will be hosting our Region 6 Educational Conference with Continuing Medical Education in Palm Springs this month from the 29th of May to the 1st
Dr.
of
Lang, you must conclude your comments. It's been more than 3 minutes.
Okay. I would just like to take this opportunity to invite the board to send a speaker to our meeting so that we could have further dialogue on this topic. And I thank you for your patience and the opportunity to address you.
Thank you, Dr. Lang, and please extend the invitation to our executive director, and we'll see what we can do. Are there any other comments from the teleconference line?
Yes, we have a comment from James. Please state your full name and affiliation. Your line's open.
Yes, my name is James E. Tucker, MD, and I just want to voice my support for the comments that were offered by Dr. Anthony Jackson and Dr. Khadijah Lang. Thank you.
Thank you. Any additional conference on the phone line?
There are no more questions. You may continue.
Thank you for those public comments. On to the next agenda item, 17. Review of responses to public comments and consideration of revised regulatory language amending section 1399.541 of Title 16, California Code of Regulations, Physician Assistant's Scope of Practice, Medical Services. Ms. Webb and Ms. Dobbs.
Thank you. I'm going to have you turn to tab 17. And this discussion is regarding the supervision of physician's assistants and the proposed regulation that's being moved forward. We did send the proposed regulations out for a 15-day comment period following the last board meeting where we struck the "or" from the language. We received comments that were not directly on point with that particular modification. However, the board does have the authority to reopen and reconsider the language, and following review of the comments and discussions with a number of counsel from DCA and counsel from our health quality enforcement team, I put forward in another modification for you to consider, and this is because the term immediately available continued to raise concerns and warranted some additional work. If you turn to page 17-3, I wish the language was in red, but it appears in my copy that it wasn't copied in color, but you can see there is a kind of a shaded area there. Gray area, where we're defining the term immediately available means the physician is physically accessible and able to return to the patient without any delay upon the request of the physician assistant to address any situation requiring the supervising physician's services. So, upon considering this language, I would ask for a motion allowing us to refer the language back to the physician assistant board so that they can consider it, and if they approve it, it will go out for another 15-day comment period.
So, okay, so we have a first. Does anybody want to second that?
I'll second it.
Okay. So no,
it's okay.
back. He's back.
Thank you, Doctor. There's been a motion and a second. Is there a additional comment from the board? Questions?
No, I think it clarifies somewhat. It happens often in the operating room where the closing portion is done by the physician assistant. The attending physician can walk out, but not out of the hospital, immediately available if they need. Some other anesthesia complications or surgery complications happens.
I thought this was well drafted and incorporated the board's comments and the public as well, so thank you to staff. An additional comment or questions from members of the board? Now we'll take public comment on the motion. I have a couple of cards, and I'll apologize in advance if I mispronounce people's names, but the first comment I have is Kimberly Kreitfeld.
That was very good.
Yes, thank you.
And I married into it, so it's not my fault.
Thank you, ma'am.
Good morning. Well, I'm Kimberly Kreifeld, and I'm a practicing physician assistant in San Diego, California, where you are. I attended the last medical board hearing in February, urging the board to consider and approve changes to clarify Title 16 of the California Code of Regulations 1399.541. While I'm disappointed that the counsels from the DCA and the Health Quality Enforcement section felt it best to bring this back to the board again after the comment period, In reviewing their comments, I feel it further defines immediately available and is very reasonable. The current recommendation does not change the intent of what we were seeking to clarify. It is worded in such a way as to further protect the consumer, yet will bring California physician assistants in line with the current medical community standards. I strongly support these changes and respectfully urge the board to do so as well. And I would like to thank you for the opportunity to address you once again.
Thank you for your comments. The next speaker would be, a public speaker is Greg Minnie. Hello, sir.
2 in a row.
2 in a row, yeah. I appreciate it.
Morning.
Morning.
I also had the opportunity to speak with you at the last meeting, and I want to thank you again for letting me come back. I've been practicing for about 20 years. In the latter part of my career, I've been doing general surgery with our chief of staff at our hospital. And when I spoke at our last meeting, I talked about we're not here to become surgeons, we're PAs, and so we just wanted to clarify the right supervision for us in the OR suites in the general surgery setting. The changes in the law that the AG added, I think, just go on to further protect us as PAs and the surgeon, and most importantly, the patient. So I wanted to thank you for having to go through this again for us and just urge your support in this particular change and finally clarifying this regulation for us. So thank you again for letting me address you.
Thank you. Are there additional comments from members of the public present? Are there comments from via the teleconference?
No comments. You may continue.
There's been a motion and a second. All those in favor?
Aye.
Opposed? Motion carries. Thank you. On to the next agenda item, which is 18, yes?
Yes.
Update on the Physician's Assistant Board. Dr. Bishop?
Very good. In early April 2014, the board... I'm sorry, thank you. In early April 2014, the board implemented the ability for applicants to submit online physician assistant applications via the Breeze system. The board is scheduled to allow licensees to submit online renewals in August of 2014. Breeze is the same online system used by the medical board. The PA Board's strategic plan was last updated in 2009. The board recently reviewed and updated the plan. A draft was presented to the board at the February 2014 meeting, and members voted to adopt the draft as their strategic plan for 2014 to 2018. The Cures system is a database that contains records of controlled substance drugs dispensed in California. For many healthcare boards, Cures data is useful in investigating complaints concerning dispensing or use of controlled substances by physician assistants. Currently, the Cures system does not have the capability to meet current and future demands and needs to be updated. Additionally, budget cuts to Cures have impacted the system as well. SB 809, signed by the governor in 2013, will address funding issues and allow for enhancements to the system to better meet the needs of the users of this information. One aspect of SB 809 is the creation of the Cures Fund. A $6 annual fee, $12 for PA renewals, will be assessed to various licensing groups, including PAs. This fee started with April 2014 renewals, as is done with licensees of the medical board. Work continues on the development of the feasibility study report between the Department of Consumer Affairs, including various boards, and the Department of Justice, which manages the Cures system. The FSR will address multiple business objectives, including automation and improvements to the Cures system, and changes to comply with legislative mandates of SB 809. Future meetings will be scheduled between DCA, including the PA Board, and DOJ to finalize the FSR and submit to the California Department of Technology for their review and approval. A diversion program fee schedule has been developed to better inform ALJs, DAGs, licensees, and applicants of typical costs involved in the participation in the board's diversion program. This document will also inform applicants and licensees of initial practice restrictions required by SB 1441 when entering the program. Other applicants and licensees are not aware of or ask about these costs. Hopefully, this document will better prepare applicants and licensees who will participate in the program and make them aware of the costs involved and initial practice restrictions. The document has also been posted to the PA Board website. The Department of Consumer Affairs is in the process of redesigning the various DCA Board websites to ensure a more updated and uniform look and to be similar in design to their website. In late February, board staff met with staff from the DCA Internet team to begin working on implementing this new design. The new site should be online in late May or early June 2014. We recently were informed by the MBC staff that all of the mandatory reporting forms used to report 800 series hospital suspensions, discipline, etc., have been updated to include physician's assistants. Previously, these forms did not include physician assistants. These forms are available on the MBC and PAB websites. The next Physician Assistant Board meeting is scheduled for May 19, 2014 in Sacramento. This concludes the report. Do you have any questions?
Thank you for that report, Dr. Bishop. Are there any questions from the board? Seeing none. Thank you, Lisa. This is 19. Are there any comments from the public in the audience on the doctor's report? Are there any comments from those on the phone?
No comment.
Thank you, Doctor, for your hard work and report. Very much appreciated. On to item 19, review of responses to public comments and consideration of revised regulatory language amending sections 1361, adding sections, this will be a little long, but so indulge me, adding sections 1361.5, 1361.51, 1361.52, 1361.53, 1361.54, and 1361.55 to Title 16, California Code of Regulations, Uniform Standards for Substance Abusing Licensees. Ms. Webb.
Thank you. I'm going to have you turn to tab 19 of your materials. And we did receive 2 comments regarding the 1441 regulations on uniform standards for substance abusing licensees, one from Consumers Union and one from CMA. So the first comment from Consumers Union is a request to add some language that appears in Uniform Standard number 4 that says that the board may reestablish a testing cycle or take any other disciplinary action if the board has suspicion that a licensee has committed a violation of a board's testing program. On page 2, I did put forward some possible language. However, my recommendation is that the board leave the language that I have as is, because it says under 1361.5 C3D that nothing precludes the board from increasing the number of random tests for any reason in addition to ordering any other disciplinary action that may be warranted. Further, under the 1361.5 C3C, the language already says that the board may order a licensee to undergo a biological fluid test on any day, at any time, including weekends and holidays. If the board has a suspicion that a licensee has committed a violation of the board's testing program, the board can order a test to occur on that day or any other day. If the test is negative, the board will continue to monitor the physician. If the test is positive, it's a major violation and additional discipline shall be ordered. If we put forward the language that Consumers Union has requested, I suspect that there's going to be additional comments questioning what will qualify as a suspicion, and this will delay implementation of the regulations and will put us beyond our year time frame, and we'll have to start the process over again. That would be warranted if I thought that the language was very important. But because I believe that our language will cover a situation if the board has a suspicion, I think our current language is cleaner. I think it's easier to understand, and therefore my recommendation is that we don't make a change to that particular section.
We're talking about Uniform Standard 4, is that right, Ms. Webb?
Yes.
Okay. Just so I'm clear, because I think I followed you. Your recommendation is to adopt the language on our board report, page 2? No, the one in red. You want to stick with the language on page 1?
That's right.
Okay, thank you.
Okay, so let me continue on with the CMA comments unless anyone has a question at this point. So CMA also sent a comment asking that we harmonize the use of negative biological fluid tests and prohibited substance under the proposed regulations. And the reason is because a physician could have a legitimate prescription, and under our abstain from use guidelines, the physician has to report to the board within a certain period of time when they're prescribed a medication. So even though a physician may have a positive test, it may not be for something that would require discipline. So CMA requests that we add some language under 1361.5 C1D, that at the end it would say, or biological fluid tests indicating that a licensee has not used, consumed, ingested, or administered to himself or herself a prohibited substance as defined in section 1361.51E. And under that section, I have carved out legitimate prescriptions. I think that this amendment is warranted, and I would recommend accepting it. They have a similar amendment to a different section, but I think that the language needs to be tweaked a little bit, and you'll see my recommendation on page 19A3, and that's just it changes testing reports to tests or biological fluid tests, which is consistent with the language that I've used throughout. And so the section 1361.53C, and I apologize, I know this is tedious hearing all these numbers, it would read negative biological fluid tests or biological fluid tests indicating that a licensee has not used, consumed, ingested, or administered to himself or herself a prohibited substance as defined in section 1361.51E for at least 6 months, and the rest, the language stays the same. And the reason why this is important is because either they'll have the negative biological fluid tests, or they'll have biological fluid tests that indicate they're not using a prohibited substance, so they could still be using a legitimate prescription. Again, I recommend that these two modifications be accepted from CMA, and I think our original language should remain that nothing precludes the board from increasing the number of random tests for any reason, in addition to ordering any other disciplinary action that may be warranted. And if you're ready for a motion, I would like to state the motion. Just let me know when.
If we could articulate the motion for discussion purposes.
Okay.
Thank you.
I would be asking for a motion to approve the recommended changes to approve the changes that I have recommended to the attached proposed language to implement the uniform standards for substance abusing licensees. I would ask that the motion further directs staff to notice the modified language for a second 15-day comment period. If no negative comments are received during the 15-day comment period, authorize the executive director to make any non-substantive changes to the proposed regulations before completing the rulemaking process and adopting Title 16 California Code of Regulations, Section 1361, and adding sections 1361.5, 1361.51, 1361.52, 1361.53, 1361.54, and 1361.55 with the modified text.
Thank you. That is the motion.
As long as we don't have to repeat that, I think I'll make the motion.
Was that a motion, Doctor?
Yes.
So moved. It's first, second, a second by Dr. Lewis. Thank you. Before we start our discussion, I wanted to say just a couple brief things. One is we are taking this action in conformance with state law, 1441. There's been a lot of work put into it by the public and staff. This is the work product, excellent work product. And I don't know, I'm expressing a personal opinion. We want to ensure we want to get as close to as possible with 1441. I think we've done that. And there could be a very strong argument for us to adopt these recommended changes today so we can begin this notice period and have the 15-day comment period and try to get these regulations on the books as soon as possible so we can begin enforcing them as soon as possible. But if it is a desire of the board to do something else, so then my question to Ms. Webb is if additional changes are made to those outside of the motion for the board, would that necessitate yet another round of comments?
If they're negative.
So we have language before us. If it's adopted, fine. If it's not adopted and it's modified here today, would that require an additional sort of comment review period, come back to the board, that sort of thing?
If you recommend accepting these comments from CMA and or from Consumers Union, it does have to go out for a 15-day comment period.
I got it. All right, thank you. Discussion from the board, please.
I think I ditto your comment, Mr. Serrano-Sewell. This took a long time. I'm so thrilled that the staff took time to really come up with a decent proposal to make it to the board. And I can tell you, as a board member, I'm tired of hearing that we don't follow the law. So that's why I think it's time that we approve this one and move on.
Additional comment from the board? Seeing none, I have comments from the public. Tina Manassian, ma'am? Do you wish to comment? You could pass and then, okay, please join us.
Good morning, board members. My name is Tina Manassian. I'm here on behalf of Consumers Union Safe Patient Project. First of all, I want to thank Ms. Webb for working with us on the language on Uniform Standards number 4. We had some concerns, but she assured us the language would help to protect patients. We are pleased that the regulation incorporates the full uniform standards, which we believe are essential tools for the board and staff to respond to these often difficult and contentious cases. We appreciate the attention you and the other members of the medical board have given this issue in recent months. I also want to thank Ms. Kirkmeyer and Ms. Simone for their time with us yesterday. We thank you for making Californians more safer, and thank you for your hard work.
Thank you. Yvonne Chung?
Good morning, Yvonne Chung with the California Medical Association. We just wanted to express our appreciation as well for your consideration of our comments. CMA has disagreed with the board on the content of the regs at different points, but at this point we are seeking clarity, and we believe that our amendments do add clarity, and we appreciate the board's consideration. Thank you.
Thank you.
Mr. Chair,
Yes.
I want this day to be noted where CMA and Consumers Union are agreeing on what we're doing.
Don't jinx anything just yet. Ms. Clavel, ma'am?
Good morning, Dr. Geneviève Clavron. I am a little bit concerned of some of the wording, and I'm glad we have 5 more days to respond to those new, that's what I understood. So I think I will hold my specific objection and recommendation within a 5-day period of time. Thank you.
Thank you for your comment.
I have one more question I forgot. Do we still have the physician program when they are, we don't anymore, that's not been, okay, I just want to make sure I had not lost that somewhere.
Did you wish to make an additional comment, Ms. Kirkmeyer?
I did. I just wanted to let the members know the year on this, which Ms. Simoes will go over in her regulatory update, is going to be before our next board meeting. If we do receive negative comments on this is one regulatory package that we don't want to lose the 1 year on. So it may be that we need to have a teleconference meeting prior to our July meeting. So I did want to put the members on notice of that. And it's okay. I just wanted to let you know that that heads up on that issue. So.
Thank you. Is there any additional comment on the phone line?
No comment.
Great. There's been a motion and a second. All those in favor?
Aye. Aye.
Opposed? Motion carries. Great work. Well, we're not, I guess we're not there yet.
No? Sure.
We're going to take a point of privilege here and take one item out of order. We're going to go to Dr. Yip's report, which is item 21, Special Faculty Permit Committee Recommendation, Approval of Applicant. Dr. Yip?
Great. Morning. The Special Faculty Permit Review Committee, which is on page 21, section 21, page 1 and 2, that held a telephone conference meeting on March 27, 2014, and reviewed one application from Stanford School of Medicine for Dr. Maria Grazia Roncarolo. She's in Milan, Italy. In addition to the special faculty permit appointment, Stanford is also requesting the board's approval for Dr. Roncarolo to be the Division Chief of Pediatric Translational and Regenerative Medicine. Her responsibility at Stanford University will be described below. She's a highly regarded, internationally known in the field of stem cell research, gene therapy, and autoimmune disease. If appointed and approved, she will be principal investigator on Stanford's application to the California Institute of Regenerative Medicine, the Alpha Clinic. She will also be co-director at the Institute of Stem Cell Biology and Regenerative Medicine. Her responsibility including integrating and leading efforts in Stanford to translate stem cell discoveries to clinical medicine bioclinical trials. She also, if approved, be the Division Chief of Pediatric Translational and Regenerative Medicine. She will also be training physician scientists and graduate students in the Institute of Stem Cell Biology and Regenerative Medicine, Immunology, Cancer Biology, and Developmental Biology. She will also mentor pediatric residents and pediatric hematology oncology fellows. So after review, the committee recommends that the board approves Dr. Roncarolo for special faculty permit appointment. And I make the following motion that the board approve Dr. Roncarolo for a business and professional code section 2168.1 A1A special faculty permit appointment at Stanford School of Medicine. Do I have a second?
Second.
It's been moved and second. Is there any discussion from the board? Seeing no discussion, are there any public comments on item 21? No public comments. Are there any comments from the phone?
No comments.
No comments. The motion's been made in second. All those in favor?
Aye.
Opposed? The motion carries.
So one more.
Yes, of course. Oh, yeah.
The committee also recommend the board approve Dr. Ron Carroll to be the Division Chief of Pediatric, Translational, and Regional Medicine at Stanford. So I make the following motion. The board approves Dr. Ron Carroll to be the Division Chief of Pediatric, Translational, and Regional Medicine at Stanford School of Medicine. We need a second.
Second.
Discussion from the board? Comments? Seeing none, are there any public comments from those in the audience? No public comments. Are there any comments from the phone?
No comments.
Seeing none. All those in favor?
Aye.
Opposed? The motion carries.
Great. Yeah, she will be an asset to California.
Yes.
I read all the publication record and all that. She only one of the two in the world that they would consider. So, thank you.
It's very special that our state stem cell bond program is attracting the best and the brightest people to our state and building that important intellectual capital and keeping us on the forefront. The fact that we can play a role in that is very special.
Wonderful. Thank you.
Thank you, Doctor. Before we go to our next agenda item will be 20. If you'll indulge me and just allow for a 3-minute break. So we will reconvene in 3 minutes sharp. I don't want to break the momentum that we're doing here, but we'll reconvene in 3 minutes.
She was very impressive.
Yeah.
She was really nice.
They should make the flight change earlier. Looks like things like
No, maybe.
even slightly and is afraid to ask for help is a danger to the public too, and they won't come forward until, as Dr. Lewis said, have harmed someone. So I think we should, I agree, look at this more closely, see how we can craft something that can work for everyone. I strongly support that.
Doctor?
Thank you. The reason I support the concept, not doing the diversion program, I think we all know that. It didn't work, it was bad. The concept is, in my mind, I think you heard me for 2.5 years, nonstop, same routine saying, prevention, prevention, prevention. That is, by treating these people, you're going to at least trying to prevent somebody harming a patient rather than just discipline them after they do the harm. So if you want to prevent, which is part of our public protection, you can't just close your eyes and say, oh, by the way, we just oppose everything because our diversion program failed. So it doesn't work that way. I totally understand we don't want another diversion program run by the medical board. I don't have any problem with that. But having some type of program to prevent patient injuries, to treat the people in the right time is the right way to go, and hospitals are not the right place. I was the medical director of a hospital for 13 years. I'm still the chair of surgery there. Hospitals are not the right places.
Take a point of privilege and make a couple of observations myself. Thank you for this discussion. A couple of things. One is we can learn from previous lessons, what worked and what didn't. We're an intelligent group of people. We have a new executive director who's doing a great job. To that point, if such a program were to come into being, however it may look, the last thing this board wants to do, and its obligation to the public and to our staff, is to set up a program that will not work and fail. We don't want to do that to our executive director and her staff. We want to fulfill whatever that mission may look like. To the point of the mission of this board and our objectives, we are a creature of the state, and it is the will of the legislative and the executive branch to modify our focus from time to time, if that is their will, and that is what they're elected to do in Sacramento. So we have to be respectful of that. Many states have similar programs. You know, they do have these programs for the policy reasons that were stated today. As a public member, I share the same concerns that my colleagues do, physicians or public members. We will never sacrifice patient safety or our primary mission, but we must be holistic. We must look at the big picture and think about how we can make sure everyone who's involved in the delivery process make sure that they're ensure their well-being to provide the best quality care. Dr. Lewis?
Can I make a motion to supporting concept? I think that may be the better way to go for this, so if colleagues will indulge me, and I'm going to make that motion.
Is there a second?
Second, and I would ask if staff perhaps could bring back a presentation from the State Bar, because the program has been very effective, it's very
Excellent
aggressive.
suggestion.
And that way everyone can see what it is that we're supporting in concept.
That's a very good suggestion. So there's been a motion and a second. We've had discussion, but we can have discussion on this particular motion, if there's any. Seeing no.
Point of order.
Yes, sir.
For the sake of fairness.
Yes.
Did we cut off
No.
Ms. Yaroslavsky, who wanted to first lead with a motion to oppose?
We did not. She was generous and allowed the board to have a discussion. Thank you, because this was a topic that warranted sort of a discussion first, get the sense of the committee, then a motion. So we've done that. I hope no member feels as though they were cut off. Okay.
Never.
Of course, thank you. So
But before you take a vote, you have to hear from the public.
Absolutely, that's where I was going. Thank you. Yeah, I have some cards, so I'll call them out in the order that I have. And if you don't have a card, or if you want to approach and just sort of wait, we'll do it that way. The first card I have is from Tina Manassian. Hi there. So you want to come on up? The public table is right here to my left. That's what I'm pointing to. Then after that, I have Julie DeLiangelo Felmuth. We have somebody from the phone, which we will get to, a Dr. Jim Hay, but if there are other members if there's those folks that are present that wish to speak, we'll do that first. Tina, thank you.
Good afternoon. My name is Tina Manassian. I was a victim of a doctor in the former Medical Board of California diversion program. I wasn't his only victim. There are countless others that suffered and are not here anymore. They've passed away. In 2002, the doctor performed a surgery on me that I wasn't a candidate for. 12 years later, I still suffer from the lingering effects of that surgery with spitting sutures and excruciating pain. During that time, he was at his all-time high with his alcoholism. And the medical board was trying to revoke his license. Two of those board members are sitting right here, Ms. Shkipsky and Ms. Yarlowski. The problem is, I didn't know any of this. He was in a secret program called diversion. But here's the clincher. He failed diversion twice. But he was allowed to continue to practice medicine. In my case, my doctor was allowed to have his own office manager to be his worksite monitor for diversion. Someone he can hire and fire, an employee. She lied for him on his AA records, and they also tried to dilute his urine. In 2005, I learned of you, the Medical Board of California. I, along with countless other victims, filed complaints with the Medical Board, and we went nationwide with our story. In 2007, the Attorney General filed multiple accusations against our doctor on our behalf. And in 2009, he lost his license. That's 7 years from the date of my injury. But keep in mind, he was still practicing medicine. The Medical Board's diversion program was a failed 27-year program. It was audited 5 times, and they failed all 5 audits. And the board, including members, Ms. Yarlowski and Ms. Skipsky, unanimously shut down that program. The problem with AB 2346, it creates another diversion program, except this one not only keeps doctors' substance abuse problems secret from patients, it also keeps it secret from you, the medical board. No mandatory reporting requirements, there's no requirement to report anything to you. Even if a doctor cheats, the the uniform standards are not being utilized. There's no requirement that the program abides by any standard.
Please conclude.
And same individuals who ran the diversion program are the same ones that are trying to run this one. AB 2346 is another diversion program. It looks like it smells like it, and it walks like it. It's a diversion program. I want to remind you, members, that your paramount priority is patient protection, not rehabbing doctors. I urge you strongly to oppose this bill. Thank you.
Thank you for your comments. Ms. Felmuth? And after Ms. Felmuth, I have Tara Kittle.
Good morning. Julie D'Angelo Felmuth from the Center for Public Interest Law. I'm also the former medical board monitor, enforcement monitor, who audited your diversion program in 2004. We oppose this bill, and we think you should oppose it as well, or at the very least demand some significant safeguards to protect patients. This bill is the fourth bill of its kind sponsored by CMA since this board unanimously voted to abolish its diversion program in 2007. The bill would authorize you to create a monitoring program for substance abusing physicians, and the program would be funded solely by fees paid by participants in the program. Unlike your former program, the bill does not propose to use physician licensing fees to cross-subsidize this program. If CMA wants to create a voluntary monitoring program for substance abusing physicians, it can do that today. It doesn't need this bill, it doesn't need legislation, and there is no need for the program to be located within the medical board. You should think long and hard about whether this program should be associated with the medical board. Your old program's location within this board actually inhibited many physicians from seeking help. And your previous program failed 5 out of 5 performance audits during its 27-year life, including the one that I did in 2004. So the program created by this bill need not be and should not be associated with the medical board. If there is some good reason to do that, then you need to consider some serious safeguards to protect patients from substance abusing physicians. That is your paramount priority. First, the program must be required to adhere to the uniform standards that you have been arguing about for 2 years and you just finalized, hopefully today. That is state law, but this bill does not require the use of the uniform standards. Second, if it is located within the medical board, the program must be required to notify the medical board's enforcement program when a participant relapses or otherwise fails to comply with the rules. There is nothing in this bill about notice to the medical board when a substance abusing physician relapses. Third, if it is located within the board, you should insist on a complete fiscal analysis. There has been none. You should insist on a sunset date and a mandatory audit, and you should insist on a provision requiring competitive bidding when you contract this out to the private sector. And you should include a provision which you demanded in 2012 when Senate Bill 1483 was on the table, a provision that precludes anyone who played a role in overseeing your former diversion program from overseeing this one. Finally, the bill itself says that the new program is modeled after a similar program at the State Bar created in 2002. This is a 2011 audit of that program. As of 2011, only 11% of the lawyers who ever participated in that program had successfully completed it. 76% of the participants dropped out. And the audit says that the program does not have a good track record of reporting to the bar attorneys who failed drug tests. We ask you to oppose this bill, and I'm happy to answer any questions that you might have.
We'll take the next speaker. Thank you.
Thank you.
Tara Kittle.
My name is Tara Kittle. I highly recommend that the board reinstate the wellness committee that used to be a part of this board, because as we have already seen, there's so many issues here regarding physician wellness and its impact on the healthcare consumer that I really do believe there should be a meeting just for that. I was actually used to come back when Divergent was falling apart, and I cannot articulate enough, as you already saw, what a mess that was. But what I noticed is a lot of that mess was actually in the eyes of the public. It was in some ways a failed public relations situation, because the general public has misconceived notions regarding what it's like to be a physician and what physician needs are in relationship to how they impact them as the healthcare consumer. And every rehabilitated physician is good for the people of California. We all go through dark times. Physicians are people as well. And if we can rehabilitate them, they can be out there then helping future patients. So I highly recommend the reinstatement of the Wellness Committee, as I feel that would be a great way to address many of these issues. Thank you.
Thank you for your comment. I have a card from Michelle Montserrat Ramos. Ma'am.
Good morning. My name is Michelle Montserrat Ramos. As some of you know, I found myself in the most tragic of circumstances when my husband-to-be, Lloyd Montserrat, died 3 days following elective surgery. I felt further victimized when I discovered that his physician had a long arrest record, including felony possession of crack cocaine and multiple prostitution arrests. Lloyd had much more than a bad experience. He's dead. Although there are many issues I could have focused on, I could not get over the fact that the state of California continued to allow this physician to practice, and to further complicate matters, neither Lloyd nor I were allowed to know that his physician had a serious drug problem. You see, I checked the medical board website and found no arrests, no disciplinary actions, nothing. It gave me a false sense of security. I had no idea that the state of California would not protect Lloyd and all the other victims of this doctor and not provide critical background information on this doctor. So I began this journey of fighting against each attempt to bring back the failed confidential diversion program, AB 214, AB 526, SB 1483. I testified before the Senate Business and Professions Diversion Hearing, where SB 1441 and the beginning of the uniform standards were introduced. Lloyd began his career organizing nurses out of LA County USC Hospital. He devoted his career to making positive change for Californians, yet the state of California failed Lloyd. I've asked you before, and I ask you again, to oppose AB 2346. AB 2346 does not mention the existence of the SB 1441 uniform standards. It keeps the program confidential from us, the patients, and from you, the board. We have been down this road so many times now. We have been debating this issue for 7 years. The bottom line is that patients need to be protective. Please oppose AB 2346.
Thank you for your comments. And then I have Yvonne Chung from CMA, and then we'll take other speakers. I'll take the woman in the front row, and then we'll go to...
It has been greater than 10 minutes of comment.
Thank you. We'll allow a little bit more, so thank you for noting that. I know that.
Okay,
thank you. Please proceed.
Yvonne Chung with the California Medical Association. We are the sponsors of this bill. We appreciate the board's discussion on this very important issue and your willingness to move to a support in concept position. This will allow us some time to work with the author and the medical board and other stakeholders to flesh out this bill more fully. I just wanted to raise a few issues. It is our intent to include a funding source for this program. The language isn't in there yet. We understand that it will, I think the estimates that Ms. Simoes presented are probably about right, although we are working on those as well. And we also intend to specify the nature of the contracting arrangement, et cetera. I just wanted, for those of you who are new to the board, I wanted to just emphasize that what we are asking for is not anything that is new to the state. Just about every other healing arts profession that offers a diversion program also has a voluntary program as well, in addition to the lawyers program that was previously mentioned. Even the osteopathic physicians have a diversion. So other physicians are currently able to avail themselves of a voluntary program. So I think that's an important point to remember. And
that, again, we agree that early detection is the best way to protect the public. Studies from other states have shown that participation in these types of programs really do increase compliance, and going forward, after 5 years, up to close to 80% of physicians have had no have had no positive drug or alcohol tests. So I'll see the rest of my time, but we do appreciate your support, and we look forward to working with you on this bill. Thank you.
Thank you. Ma'am, and then we'll go to Ms. McGifford, if you still wanted to make a comment. Please keep your comments short and concise. Thank you.
That's one thing I have learned by testifying at the Board of Supervisors. I do very in 1 minute. Geneviève Clavrol. That's a huge issue for me because actually I got crippled because of a drunk physician, and all of his colleagues knew he was drunk when he was doing surgery and so on, and nobody ever reported him. And I found out much later that the reason I was in the shape I was is because he was drunk when he did the surgery on me. And he's still practicing now. I think you should oppose this bill. First of all, I think it should be done by outside agency, so it's no, hanky-panky going on. I see like the nursing board have a program, and I don't think it's very good, so please oppose.
Thank you for those comments. We have well, wait 1 second. Oh, come on in. Yeah, appreciate it.
I'm Lisa McGifford with Consumers Union Safe Patient Project, and we also strongly oppose this bill, and we ask you to oppose it. This bill didn't even exist a week ago, and there has not been enough time for the board and the public and elected officials to thoroughly review it and its implications. So in addition to all the comments that were made by consumer advocates prior to my testimony, and I support their comments, I'd like to just reiterate that it is not your role to treat and make sure that physicians get the treatment they need. Your role is to act when you receive complaints and to act appropriately. And if you feel that someone has a substance abuse problem, you put that treatment in their probation, and they go into that treatment. There is nothing preventing physicians from getting confidential treatment today. Voluntary confidential treatment is available to them more than probably most any population in the country. They have resources, they can go out of the state, they can do all kinds of things to get this kind of treatment. I have had experience with this program in other states. In Texas, I collaborated many years ago with the medical board to come up with conditions for their diversion program. They were strong conditions. 3 years later, in an audit, every single one of those conditions was violated, and the program continues. So I think that there's a fundamental flaw in this concept. It is not your role to make sure that physicians get treatment. It's your role to protect patients. And when you know of a physician that has a substance abuse problem, the patients that doctor is seeing have a right to know it also. Thank you.
Thank you for your comments. Are there any additional public comments from those present? Are there any comments from, I have one from on the phone from a Dr. Jim Hay. Sir?
Thank you, Mr. Chair. Can you hear me?
Yes.
Okay, I'm Jim Hay. I'm a family physician in San Diego. I'm currently seeing patients who have been waiting for me for 45 minutes, and I'm happy to be here with you now. I'm the chair of California Public Protection and Physician Health, and I'm a past president of CMA. I hope to have the opportunity so you can understand why creation of a physician health program in California is so important. Most of you are physicians like me, and all of us believe strongly in preventive and evidence-based medicine. Our current method of dealing with physicians who have potentially impairing substance abuse, psychological, or medical problems is neither of those. Let me review the evidence. Prior to 2008, this board monitored between 250 and 350 such physicians at any one time. Now look at your own statistics about how many are monitored with problems that might put patients at risk, and compare even those numbers with from the past to the 700 participants in the Florida program, a a state with 1/3 the licensees of California. The Federation of State Physician Health Programs estimates that a fully functioning PHP should be identifying and monitoring between 1 and 1.5% of the licensees. And in our state, that would be well over 1,000. Successful programs are successful because they identify the problem before the physician gets to the attention of their licensing board. They do so entirely because they have confidential and supportive systems that encourage participation as opposed to enforcement-only methods that clearly discourage not only self-referral but also colleague referral. Enforcement only is like looking only for the stage 4 cancers rather than teaching proper diet and healthy habits to prevent disease in the first place. The evidence is there. Fact, the president of the Federation of State Medical Boards, that's your organization, spoke to us in Denver last week and reiterated their policy that reaffirms, and I quote this, that, quote, the medical boards and PHPs should work collaboratively in the development of effective laws and regulations in the promotion of PHPs for the benefit of the public, unquote. He or one of his peers is willing to come and testify here if you think it's necessary. Fact, Colorado published a study a year ago showing that physicians participating in PHPs and after completion of their participation were less likely than the general population of physicians to be involved in malpractice lawsuits or complaints to their medical board. Fact, there were 2 reports in 2009, one published in the British Medical Journal and the other in the Journal of Substance Abuse Treatment, both showing that over 75% of PHP participants who completed their program returned to practice safely. In fact, the treatment programs that were referred to earlier, who everyone thinks can take care of everybody, are the very ones, that's Promises, that's Betty Ford, that's the physician health, the well-being committees within the medical staffs, are the ones that are pushing us to help create a statewide program. So if the board is currently monitoring about 100 doctors with these problems, and the rest of the country says that number should be over 1,000, where are the 900? They're out there making California patients less safe now than they were before, regardless of the flaws of any prior program. This bill allows the development of a new way to do
Doctor,
business,
please
not in
conclude
any
your
way
statements.
diverting doctors from enforcement if they have already gotten to the point of putting patients at risk and being reported to you, but expanding into prevention and early identification of doctors who are stressed,
Dr. Hay.
problematic by their behaviors at work, or suffering neurological or medical problems that should be monitored for their benefit and to protect those they care for. What we're doing now isn't working. I'm just about done. And we are an outlier in this country, marveled at by those experts elsewhere who know how to help doctors and protect the public.
Thank you, Doctor.
Pay attention to the evidence and not the rhetoric of those who would suggest that enforcement only is the way. Let's work together to...
You're going to have to...
Thank you, Doctor. We get the gist of your comments. Are there any other comments on the teleconference line?
No comments. No comments, thank you.
There's been a motion. It's been first and seconded. I do want to emphasize it is in concept. That remains a major asterisk for this particular motion. Today's comments were extremely helpful in informing our dialogue, staff's dialogue with the author's office, and clearly some changes will need to be made should it proceed. All those in favor of the motion?
I don't think we've completed board discussion.
Well, I apologize.
Can I just add something really fast? When I do a letter, I kind of have to say we support the concept of. So we're supporting the concept of having some kind of physician health program, physician surgeon assistance program, but not necessarily within the board. Is that correct? I just wanted to make sure I had it clarified before.
I made a point of clarification. I think the idea of supporting the concept of diversion is important. Mm-hmm. The question is who should undertake this program.
Yeah.
Now, I've had more experience in diversion than probably anybody in this board. First, because I was a judge and I put people who failed on diversion into the place they didn't have choice.
Mm-hmm.
Second thing, I was in state bar, put in charge of the state bar disciplinary system by the Supreme Court when this system was discussed. So I think the problem here is what we need is not say diversion is not a good thing. Diversion is a great thing. But whether the medical board is the disciplinary system should undertake that. Now, the bar is different in its concept. The bar is a unified bar. You have to be a member of the bar in order to be a member, practicing lawyer in California. You have to get a license here, but the disciplinary system is done by the bar by its own agency, and now we have a split here. So you can have a diversion program, maybe it should be CMA. CMA doesn't want to do it, probably, but maybe someone divorced from the board, because we have, you know, when you're trying to wear two hats and do too many things, it gets very complicated. Now we have three hats. We have the Department of Consumer Affairs, and we have the medical board, and now we have a diversion program. I think diversion is great, but whether this board can undertake to do this while it has its other role. And the roles are defined by the legislature, so the legislature has not yet given us this role, so we don't have this role yet. But if it gives it to it, we'll have the role. The question is whether we can and should undertake this task rather than anything else.
Okay, Dr. Kraus?
My concern is really in taking any position today on a bill that we think still needs work. Perhaps we agree that there needs to be a physician health program. Perhaps we agree that we'd like to be part of the process in working that out.
Mm-hmm.
I have my own reservations that the current legislative cycle might actually be too short to conclude that. I am very concerned about the public comment that we've heard today, and I think it's critical that we do protect the public. Some of the safeguards that were mentioned today I think are important. I think if there is a physician health program that we support, that the board should have some knowledge, even if it's confidential knowledge, as to who's participating in this program, that we should have knowledge of who falls out of the program, and we should have triggers where it changes from a physician health program to a disciplinary process for people who are not compliant. These are all important details, and I don't know if they can all get into this particular bill in timely fashion. But on the other hand, it concerns me that we would have a public opposed position to a bill that we support in concept. So I don't know if at today's board meeting we should take a public support position, but I don't want us to take a public opposed position.
Yeah.
So one option might be for us to have no position, but I do want us to leave today with the full intent and purpose of collaborating with CMA and other interested parties on a physician health program.
Thank you, Dr. Kraus. I mean, that really, one moment, please. That really just articulates sort of the frustration that I have sometimes, where we have boxed positions, yes, no, and on occasion there are nuances that require we have to go out. We can't just be limited with what usually works for us, which is a yes or a no, or an in concept. So
what I was going to recommend, and I didn't want anyone to take from my comments that I do not support diversion in its true form and responsibility of good, but I'm going to recommend to table this motion now, to allow staff the opportunity to do what they feel is necessary, either through the proposed agenda item in July, or an interested parties meeting, or a letter to CMA that we would be interested in work. I don't know where you want to go, but I'm going to suggest that.
Let me try, take a stab. I think that's an excellent suggestion. And because the issue is so nuanced, it's hard to capture it all in one sentence. So if it's the pleasure of the board, let me try to do that, and maybe work with Dr. Levine. She'll hear the transcripts from this as well, and we'll take it to the next level. And that is to work with staff, work with the author, to encompass all the comments that were made today, collect them, organize them in a reasonable manner so we can all have a meaningful discussion with the author's office, which I think is important, not necessarily the sponsor, CMA per se. I don't know. The author will do that on his or her own. We don't need to do that. Work with other stakeholders and come up with a discussion, report back to this board, and it may fit in very neatly with Ms. Wright's suggestion for that agenda item. So I don't know if you need a motion for that, but that is the sense that I'm getting from this board.
That's why I made it was.
And we could do it. We can just do it.
A motion to table takes precedence.
Sure. If it incorporates what I tried to summarize, I think it does. Okay. There's a motion to table. Is there a second?
Second.
A motion to table doesn't need a second, but that's fine.
This is a substitute motion. There's
Thank
a
you.
motion on the floor.
I should seek advice from counsel, but I think what we want to do is withdraw the motion to support and substitute it with a motion to table.
You have to make a substitute.
Hold on. However, it's Ms. Shipsky, maybe you can give us some guidance on this.
You have to make a substitute because there's a motion on the floor. So either
Okay.
you get the makers of the motion to withdraw
Got
or
it.
make a friendly amendment, or you do a substitute to the motion.
Okay, thank you. Do you want to comment, Ms. Webb at all?
I just, is Dr. Lewis withdrawing his motion?
Yeah,
That
that was
makes
where
it
I was
easy.
gonna go, yeah.
It makes it easy. I withdraw the motion, and then we support the motion.
Yeah.
Okay.
Just withdraw the motion.
All right, the motion has been withdrawn. The maker of the motion agrees.
Just one point, though. Only discussion on motion to table is the time to when? To when? July, May board meeting? Is that what? You have to have a time on the motion to table.
We'll work that out.
That's Robert's
I think what we're doing is turning the
The
responsibility
parliament-
back to staff.
Yes,
To be
that's
honest
the
with you, a
intent.
motion to table is on the table.
Yes,
And
ma'am.
in all due fairness, it doesn't, this is continuing a discussion.
It
that's
was the
inappropriate.
overabundance of caution. Thank you.
It's inappropriate.
What's that? Yes, Ms. Kirkmeyer?
Could I make a comment as well? I mean, I think we have created task force for issues that are of great importance, and this perhaps is one of the more overriding and issues of greatest importance. So perhaps as we table this till the next thing, we should consider and instruct staff to consider creation of a task force which could address these with all the, you don't have to, I'm just mentioning that as a topic.
Thank you, Dr. Bishop. Ms. Kirkmeyer?
I just want to let everybody know, by not taking a position today, when there are hearings on this bill, we will not be going forward with any position from the medical board. That's one reason we do take positions, is so when we go to the hearing and we won't be able to go forward and make any comments, that things that Ms. Falmouth or that Dr. Kraus pointed out, we won't be able to bring those forward at any hearing with that. If that's my understanding, right, Ms. Smoes? So I know we're going to work together and we'll be able to get back to the author's office what came out today.
That's correct. And before our board, this all happened kind of fast. I know that it was mentioned before. Before we met here today, I already committed to meet with the author's office, to meet with the sponsors, to sit down and try to work something out. I reminded them that we were okay with SB 1483, and they kind of made a commitment to try to build off of that. So, I mean, I think regardless of what we do here today, staff is going to be actively working with the author's office and the sponsor. So I just wanted to put that out there.
Okay. All those in favor of the motion to table, say aye.
Aye.
Opposed? Motion is tabled. Next item?
Okay, the next item is SB 1258, DeSaulnier. And this bill would require all prescriptions for Schedule 2, 3, 4, and 5 controlled substances beginning January 1st, 2016 to be submitted electronically and to comply with the Drug Enforcement Administration regulations. For medical practices with 2 or fewer physicians, and for medical providers in underserved rural areas, these electronic prescribing requirements would be effective January 1st, 2017. This bill would provide an exception to the electronic prescribing requirement if technological failure prevents the electronic transmission of the prescription. This bill also adds Schedule 5 controlled substances to those that have to be reported to cures. This bill would allow an individual designated by a board, bureau, or program within DCA to access cures data for investigation purposes if an application is submitted to DOJ to obtain approval to access this information. This bill would require the application to contain facts demonstrating the probable cause to believe the licensee has violated a law governing controlled substances. According to the author's office, this provision would allow designated DCA investigators to access cures information. However, with the move of our investigators to DCA, this provision could be problematic. Lastly, this bill would establish controlled substances dispensing limits. This bill would not allow a person to prescribe, fill, compound, or dispense a prescription for a controlled substance in a quantity exceeding a 30-day supply. This bill would provide an exception to this limit and allow for a 90-day supply if the prescription is issued in treatment for either a panic disorder, attention deficit disorder, a chronic debilitating neurological condition characterized as a movement disorder or exhibiting seizure, convulsive, or spasm activity, for pain in patients with conditions or diseases known to be chronic or incurable, for narcolepsy, or any other condition or circumstance for which the physician determines as a medical necessity, provided the reason for the medical necessity is noted in the prescription and in the patient's medical record. This bill would not allow a prescription for a controlled substance to be prescribed, filled, compounded, or dispensed if another prescription for that controlled substance was issued within the immediately preceding 30 days until the patient has exhausted all but a 7-day supply of that controlled substance from the previous prescription. This bill now states that this section would not prohibit a patient from being issued multiple prescriptions, each for a different controlled substance at a given time. This is a bill kind of like the bill that we discussed before, where there's a lot of things to work through. In the past, we have taken the support and concept position on prior cures bills, where we support the concept maybe of electronic prescribing as a goal that we should be moving towards, or we support the concept of inputting data into cures, or maybe coming up with some dispensing limits, but this bill still has a lot of work to go. So staff is suggesting that the board again take a support and concept on this bill. We recognize that it's not in the perfect place, but we think that the board should be supportive of, electronic prescribing in the future, of inputting data into cures, and then work with the author's office and interested parties. So staff is suggesting a support and concept position.
Is there a motion? There's a motion and a second. Any board discussion?
Yeah, this bill needs so much work. Schedule 5 is Robitussin AC. I mean, come on, give me a break. I mean, this is micromanagement of medical practice. It does not make sense. The concept is fine with us, but God, this bill needs work. This goes beyond legislature totally practicing clinical practice of medicine, which is inappropriate in my mind as a physician. You got to go through med school to do this.
Is there additional board comment? I guess that will be included in our communication as well, that we think it's too prescriptive. Is there any comment from the public? Yes? Why don't you come up, Ms. Chung, that we're ready for you.
Geneviève Claverol. Actually, I sent a letter to all the members who sponsors that bill. It's a horrible bill. So anything good about it is to prescribe, to the internet, which I'm totally in favor. All the rest, those legislators do not have a medical license, and that should not be prescribing. And that's what that bill is all about. And I'm not the only person. I think many people with SPIN will totally agree that is overreaching and is poorly written, and is a lot of conflicts the way it is worded. And I don't think you should take a position about it. That's not the job of the legislator. Thank you.
Thank you. Ms. Chung?
I'd be glad to give you the letter I sent to all the legislators.
I appreciate that.
Dawn Chung with the California Medical Association. I'll keep my comments brief. We appreciate Dr. Ganaudev's comments. CMA is an opposed position on this bill for 3 main issues. One, the e-prescribing requirements related to controlled substances are we believe are infeasible at this time. It's governed by the DEA, and we've been surveying physicians, and we don't know, it's hard to find anybody who's really able to do this in a meaningful way. The second point is that it is overly prescriptive in terms of determining how much a physician may prescribe. It's really legislating the practice of medicine. It imposes a lot of new requirements on the cure system as well at a time when we are in the process of trying to upgrade that system, trying to changing the requirements while you're already upgrading the system creates huge problems. So we believe that the intent of the bill is to curb prescription drug abuse, but we really need to balance that with what physicians need to do for their patients. Thank you.
Thank you. Is there additional public comment from those present? Any on the telephone?
No comments.
Seeing none, all those in favor of the motion to support? In concept?
Aye.
Aye. Opposed? Motion carries.
And I just will remind everyone, I'm going to be bringing this back in July, so if it hasn't met what we would like to meet, we can always take a different position.
Thank you.
I just wanted to make sure that Mr. Moss knows that the discussion, what it is, concept is totally different from supporting the bill.
Absolutely.
Definitely. Yes, and I will make sure the author's office knows that.
Final item.
Final item. SB 1262 Correa, this is the second medical marijuana bill. This would put various licensing and enforcement requirements on medical marijuana dispensaries and cultivation facilities and would also put requirements on physicians recommending medical marijuana in the board. However, this analysis will only cover the portion of the bill related to the requirements on physicians in the board. So SB 1262 would require physicians, prior to recommending medical marijuana, to meet the following requirements: have a doctor-patient relationship, conduct an appropriate prior examination of the patient to establish that medical use of marijuana is appropriate, consult with the patient as necessary, and periodically review the treatment's efficacy. A physician that recommends medical marijuana, would be required to do all of the following: include a discussion of the side effects, address in the recommendation what kind of marijuana to obtain, including high, let's just call it THC levels, low THC levels, high cannabidiol CBD levels, low CBD levels, and explain the reason for recommending that particular strain. Under no circumstances shall a physician recommend butane hash oil. Physician must maintain a system of record keeping that supports the decision to recommend the use of medical marijuana for individual patients. And if recommending medical marijuana to a minor under 21 years of age, the recommendation must be approved by a board-certified pediatrician and must be for high CBD marijuana and for non-smoking delivery. This bill would make it unprofessional conduct if a physician recommends medical marijuana without an appropriate prior examination and a medical indication, or recommends marijuana for non-medical purposes. This bill would also subject physicians recommending medical marijuana to the laws in BMP Code Section 650.01 and would not allow a physician to accept, solicit, or offer any form of remuneration from or to a licensed dispenser, producer, or processor of cannabis products in which the licensee or his or her immediate family has a financial interest. And this bill would not allow a physician to advertise for medical marijuana recommendations unless the advertisement meets the requirements in our advertising section 651. This bill would also require the board by January 1st, 2016 to convene a task force of experts in the use of medical marijuana to review and update as necessary physician guidelines for recommending medical marijuana to ensure the competent review in cases concerning the recommendation of marijuana for medical purposes. This bill, like the last bill, would give the board some needed enforcement tools to more efficiently regulate physicians who recommend medical marijuana. It expressly spells out what a physician must do before medical marijuana is recommended and what a physician must do if a medical marijuana recommendation is issued. And it places appropriate anti-kickback and advertising restrictions on physicians who recommend medical marijuana and directly ties noncompliance with some of these requirements to unprofessional conduct. However, the board staff does have some concerns with some of the provisions in this bill. Requiring a physician to address in the recommendation what kind of marijuana to obtain, including high THC levels, low THC levels, high CBD levels, and low CBD levels, and explain the reason for recommending that particular strain is problematic. Board staff is concerned that unless medical marijuana is regulated by the FDA, physicians may not know the appropriate type of marijuana to recommend or be able to explain the reason for recommending a particular strain. In addition, the board's physician experts that review enforcement cases may also not be knowledgeable in the appropriate particular strain a physician should be recommending. Secondly, requiring the task force created by this bill to review and update physician guidelines for recommending medical marijuana to ensure the competent review of cases concerning medical marijuana recommendations is another area of concern. The board could convene a task force to look at the current statement adopted by the board related to medical marijuana and update that statement with information that will be contained in the revised pain management guidelines and with information on the new laws that are contained in this bill. However, board staff strongly believes that the guidelines are there to guide physicians recommending marijuana. Board staff believes the competent review portion of this provision should be removed. So board staff is suggesting an opposed unless amended position on this bill.
It's been moved and seconded. Any board discussion? Dr. Kraus?
I agree completely. I mean, to me, the term medical marijuana is an oxymoron. And then to micromanage the prescription, so to speak, for marijuana is even of greater absurdity. It would require a prolonged program of continuing medical education in a smoke-filled room to begin to comply with that law. So I'm in support of our position.
Thank you for those comments. Are there additional comments from the board? Seeing none, any public comments from those present? Seeing none, any comments from those on the phone?
No comments.
There's been a motion to oppose. All those in favor?
Aye.
It's oppose unless.
Amended.
Oh, thank you. Thank you. I appreciate that. Oppose unless amended. All those in favor?
Aye.
Opposed? Seeing none, the motion carries. Thank you for your report.
Sure, and so that concludes my presentation. Agenda item 20B is the status of regulatory actions, and that matrix is in your board packet. So I don't really have anything to add to that matrix unless members have questions.
Are there any questions from the board members? I see none. We will proceed to the next agenda item. Item 22. Update on consideration of recommendations from the Midwifery Advisory Council. Aaron, hello. We'll be taking, I think, 2 action items, approval of future agenda items and approval of licensed midwife practice guidelines. Hello, good to see you.
Same here, always. I am here as vice chairwoman today because Carrie Sparavon had an accident and is medically unable to be here for the moment. She's
Send our
okay.
thoughts. Okay,
she's
good.
okay. I believe that what you see in your packet is completely adequate. I don't believe I need to read it to you unless you want me to. Is there anybody who has questions or issues or would like me to read this?
I assume that our colleagues have read it and looked at it. Are there any questions? May I have a motion to approve the agenda items for discussion at the MAC?
So moved.
Second.
It's been moved and seconded. Any discussion from the board? Seeing none, are there public comments from those present? Yes, ma'am, please. When is that meeting?
In August 14th, I believe it is.
Thank you. August 14th is the meeting. Thank you for that clarification.
Comments from the phone.
I think that was a no.
Comments on the phone.
Seeing no comments on the phone as well. All those in favor of the motion?
Aye.
Opposed? Motion carries. Thank you. Ms. Webb is going to talk about the next item.
If you turn to your materials at page 22B1, you'll see my cover letter with regard to an update to what was once called the Standards of Care for California Licensed Midwives. With the new legislation from AB 1308, Bonilla, that went into effect January 1st of this year, there were some changes to the law affecting licensed midwives. And it did remove the authority to have these standards of care that have been in our regulations since 2005. What we did with this document is change the language to reflect practice guidelines for the licensed midwives and merely brought it into compliance with the new law that removed physician supervision, but also put additional restrictions on licensed midwives and who was an appropriate client for a licensed midwife. And so I would like to have a motion to adopt these practice guidelines for midwives, to put this on our website, and also to authorize staff to make any non-substantive changes to these guidelines as we go through them and prepare them to go on the website.
So moved.
It's been moved and seconded. Is there any discussion or questions from the board? Seeing none, are there any public comment from those present? I see none. From the telephone?
No comments.
All those in favor of the motion?
Aye.
Opposed? Motion carries. Thank you for that report.
The most difficult one I've ever done.
Recent one, not
Next is agenda item 13, agenda items for the July 24th, 25th, 2014 meeting in the Sacramento area. I do note for the colleagues that one of our many items for that agenda will include the election of officers, the 2015 board meeting dates, so please bring your calendar. In addition to Ms. Wright's request for an agendized item, do any of the other members have additional agenda items for that July board meeting?
I would like to suggest an item, perhaps not that meeting, but in the future, for the board to consider what the licensing guidelines should be for California physicians.
Okay, thank you. That's right.
Let me fully state what my agenda item is now, because it's shifted based on the public comment. So if we could get some statistics as to the rate of physician impairment, whether it be mental health or substance abuse. In addition, if we can work with stakeholders and public interest groups to find out what their take is on it. And then if staff could give us some options as to what we can do, since we've agreed that diversion in the sense of what we used to do was not the best option, but something that we can do in order to assist in this area.
Okay, thank you for the clarification. Dr. Lewis?
I think Ms. Shipsky had an agenda item, but I don't know if it's...
She's on your left.
Where is she? Did you
On
have
your
one?
left.
Sure, did you have one about the State Bar making a presentation?
Yes.
That was a great suggestion.
I can add that to the one that...
Yeah, we can,
Yeah,
we'll find a way to neatly agendize everything. Are there any additional suggestions that we can pass along to the leadership? Okay. Is there any, I do have public comment from those in the audience. Lisa McGiffert?
Should not be, but God knows they're, you know, I grew up here in San Diego.
Lisa McGiffert with Consumers Union Safe Patient Project. I'll be quick. We would like you to consider adding to your next agenda the issue of disclosure of probation status to patients. So when physicians are on probation, methods to disclose that to patients and options. Also, we would like to put the statute of limitations issue on the agenda of the enforcement committee or the board. One thing that we would like to be discussed on is improving communications with the public about the meaning of statute of limitations. It's a very confusing law, and we are working with staff to try to work on that, but also to start in motion discussions about changing the current law relating to statute of limitations that actually ties how long it takes the board to complete investigation to how long a patient has to file a case. And we think that is a flaw in the system, and we'd like to get you guys to start thinking about it and talking about it.
Thank you.
That's it. Thank you.
Appreciate that. Is there any additional public comment? For agenda items, suggestions for agenda item at our July meeting? And then
I would like to bring your attention to a agenda. A bill was going to go to the voter in November. Is the Patient Safety Act of 2014, and I don't know if any of you are aware of it at all.
we are.
You are?
It's been in the press.
Okay. Well, anyway, I have done a in-depth research on the issue, so you can go back and search it. And I feel that's a poison issue. I think I'm totally in favor of the MICRA, tied up to inflation. I don't think physicians should be tested randomly for drug addiction. If they could do that, then they could test nurses and everybody else in the healthcare system. And the CURE program, and if you brought the issue 2-3 times, I listened to the pharmacy board a couple of days ago, and the utilization of CURE is less than 17%. And when they did their research in Northern California, out of 70 pharmacies they contacted, 7 responded. So it's not what it's supposed to be.
Thank you for that comment. Is there any additional public comment on agenda item 23?
My name is Tara Kittle. I just wanted to reinforce the issue of encouraging the establishment of the Wellness Committee for this board. I know there was a reference to some powerful testimony we had heard, and I think it's important to note as well the other side. I don't normally talk about myself, but when I first got really sick, one of the doctors who was instrumental in keeping me alive, Dr. Mark Abrams, was being investigated by this board, and he ended up committing suicide. If it wasn't for this physician, I wouldn't even be here today, and I used to go back and visit him once a year to thank him and let him know what I was doing, and when the year came, I called him and his number wasn't available anymore. So then I Googled him, and I was just shocked to see that the stress and the pressure that he was under led him to suicide. And what a loss that is for us. Even if he wasn't to practice medicine anymore, just the loss of him in the community to the people of California is, I can't even put words around it. So this is a very, very, very important issue on both sides, and I really hope to see, and I look forward to seeing the future presentations as we go forward.
Thank you. Thank you. Is there any additional comment? Is there any comment from the telephone?
No comments.
Seeing none before we invoke the last item, I wanted to thank Kimberly Kirkmeyer and her staff, the audiovisual team, Caesar, and Aaron. Thank you so much. And of course, the public for attending today's meeting. It's been very informative and productive. Thank you, members. Without objection, the meeting stands adjourned.
Thank you. All right, do you need to write somewhere?